If you're navigating divorce or separation right now, you're probably feeling overwhelmed, uncertain, and maybe even a little lost. Especially when it comes to protecting your financial future, you're in the right place. This is the Soft Landing Divorce Podcast, where we prove that even in the midst of ending a marriage, you can move forward with dignity, clarity, and yes, peace. But here's what makes us different. Ken and Sarah are going to share solutions and strategies that will open your eyes to things unseen by most approaches the divorce industrial complex never talks about. Today, they're revealing how to safeguard your financial future during divorce without endless court battles, even if you've never managed the finances before. These are the money-saving, sanity-preserving strategies that traditional divorce professionals won't tell you exist. Whether you're just starting to consider separation or you're deep in the process, our goal is simple: to help you and your children land as softly as possible on the other side, financially secure and emotionally intact. So grab your coffee, get comfortable, and let's dive in as Ken and Sarah reveal what the industry doesn't want you to know about protecting what matters most.
Hey everyone, welcome back. I've got something fresh and absolutely crucial for you today on the Soft Landing Divorce Podcast. We're diving deep into something that, honestly, most people want to avoid but absolutely can't when going through divorce. And that's the importance of full financial disclosure in divorce proceedings.
Oh, Sarah, you're absolutely right. And I see this all the time. People come to me and they're like, Ken, do I really need to dig up all these old documents? And I'm like, yes, you absolutely do. This is what I call the really big domino, because if this isn't sorted, everything else just stalls completely.
I'm so glad you brought up that domino metaphor because I think people don't realize how everything's connected, right? So Ken, for our listeners who might not know you yet, you're a certified divorce financial analyst and accredited family mediator who's been guiding couples through separation since 2010. You work with families across Ontario through your soft landing divorce settlement method.
That's right. And, and what I've learned in nearly 2 decades of doing this work is that financial disclosure, it's like the foundation of your house. You can't build anything solid without it. And when people try to skip it or do it halfway, it just creates this massive mess later on.
Okay, so let's start with the basics here. When someone's going through a divorce and their lawyer keeps calling about financial disclosure, what exactly are we talking about? Like, what is financial disclosure?
So financial disclosure is this mandatory legal process where both spouses, and I really want to emphasize both spouses, have to provide complete documentation of their entire financial situation. We're talking assets, debts, income, expenses, the whole 9 yards. And it's not just current stuff, Sarah. We need information for 3 key dates: the date of marriage, the date of separation, and the current date.
3 different dates? That sounds like a lot of paperwork already. But why is this legally required? Like, what's the point of all this documentation?
Well, transparency is everything in family law. And think about it this way. How can you possibly divide assets fairly if you don't know what assets exist, right? The Family Law Act in Ontario actually stipulates this requirement in Section 8. Each spouse has to serve and file a statement that's confirmed by oath. So you're literally swearing under penalty that this information is accurate.
Wait, hold on. Confirmed by oath? So this isn't just like filling out a form. There are real legal consequences if you're not honest.
Absolutely. And this is where people get into serious trouble. By signing that financial statement, you're completing a sworn statement, which is akin to being under oath in court. I've seen cases where deliberate dishonesty has resulted in imprisonment, though more often it's verbal warnings or fines. But Sarah, make no mistake, this is a serious offense.
Wow. So the stakes are really high here, but I'm curious, what does complete financial disclosure actually look like? Like, what documents are we talking about?
Oh, it's comprehensive. Banking documents, bank statements, RRSP verification, GIC certificates, trust documents, property information, appraisals, mortgage statements, credit card statements, income records, tax returns for the last 3 years, notices of assessment, pension valuations, and depending on your situation, we might need business valuations, especially if you're self-employed.
That's a massive amount of information, and I imagine people have different reactions to being asked for all of this. What kind of pushback do you see?
Oh, Sarah, the objections are pretty common and honestly understandable from an emotional standpoint. People say things like, but my spouse already knows all this information, or we've agreed to everything ourselves, so why do we need formal disclosure? Privacy concerns are huge too. Nobody likes sharing personal financial details. And there's this perception that it's just an administrative burden.
Those objections, like, they actually sound pretty reasonable on the surface, so why aren't they valid? What's the real issue with trying to skip this step?
Here's the thing, and this is crucial. Without complete financial disclosure, courts can set aside or invalidate your entire separation agreement. Your whole agreement becomes unenforceable. I've seen people spend thousands on agreements that are essentially worthless because they cut corners on disclosure. It's like building on quicksand.
That's terrifying. So even if both people agree to everything informally, it could all fall apart later because they didn't do the paperwork properly.
Exactly. And think about the ripple effects. You've got wasted time and money on invalid agreements, increased legal costs for redrafting, damaged credibility in future negotiations, plus potential court intervention and penalties. The hidden information usually surfaces eventually anyway, and when it does, it causes way more problems than just being upfront from the beginning.
Have you ever thought about it that way, like how trying to hide something actually makes everything worse in the long run? But Ken, I'm wondering about the different levels of this process. Is it the same for everyone, or does it vary depending on the situation?
Great question. There are actually 6 different levels of disclosure, and they build on each other based on complexity. Level 1 is just the basic information provision. That's where we use financial statements like Form 1.3 or Form 1.3.1. Level 2 requires supporting documents, tax returns, employment statements, bank records. Level 3 gets into additional documentation like pension records and property assessments.
And what about the higher levels? It sounds like it can get pretty complex.
Oh, it absolutely can. Level 4 is about supporting or defending specific claims. Like if you're trying to exclude inherited property, you need detailed documentation. Level 5 involves professional valuations for certain assets to determine fair market value. And level 6, that's a full audit. That happens when the provided information is insufficient or unreliable, especially with self-employment or complex financial structures.
A full audit sounds expensive and time-consuming. But speaking of costs, why is financial disclosure so expensive in general? I mean, people are already dealing with the cost of divorce.
The expense really reflects the extensive work involved. Legal professionals have to carefully examine every document, and I'm talking about costs of $200 or more per interaction, even for incorrect submissions. Multiple rounds of communication are usually necessary. Document collection happens during emotionally challenging times, which leads to delays and complications. And thorough disclosure is essential for creating a legally sound agreement.
So it's expensive because it's thorough and legally necessary, but are there ways to reduce some of these costs?
Absolutely. Being organized is key. Keep thorough financial records, submit complete documents up front, and I mean complete, like all pages and attachments. Avoid selective disclosure because missing information triggers costly follow-up requests. Maintain clear filing systems for both digital and paper records. Working systematically with your legal team and providing comprehensive documentation early can lead to significant cost savings.
That makes sense. Being proactive saves money in the long run. But what happens when one person is cooperative and the other isn't? Like, what if someone's ex-spouse is just dragging their feet or refusing to provide information?
Oh, this is frustrating, but there are legal remedies. You can file a court motion to compel disclosure within a specific time frame. Request appointment of a forensic accountant to investigate and document financial details. Seek court-ordered deadlines with potential penalties. Apply for a case management conference. And the court takes deliberate delays seriously. They have various enforcement mechanisms to protect the cooperative party.
Good to know there are options. Now, you mentioned Forms 13 and 13.1 earlier. Can you break down which form people need to use and when?
Sure thing. Form 13 is the financial statement for support claims. You use this when you're making or responding to spousal support claims, responding to child support claims, or requesting child support amounts different from standard guidelines. Form 13.1 is for property and support claims. That's when you're dealing with property division, equalization payments, or matrimonial home matters.
And these forms, they require specific supporting documentation, right? What exactly do people need to gather?
The forms require comprehensive income and financial information as mandated by child support guidelines, tax returns, and notices of assessment for the last 3 years, detailed employment and business income statements, bank statements, pension records, real property assessments, and the documentation needs to cover those key valuation dates, particularly the separation date.
Let me ask you something practical here. How many months of bank statements do people typically need to provide?
Most proceedings require 6-12 months of bank statements, but it can vary based on complexity. Courts may request up to 12 months if there are concerns about financial misconduct or suspicious transactions. Bank statements help establish regular income patterns, spending habits, joint account activity, and they're crucial for identifying potential hidden assets.
Hidden assets? That sounds like something out of a movie, but I guess it's a real concern. What about tax returns specifically? Do people have to share those with their ex?
Yes, tax returns must be shared as part of mandatory disclosure, typically the past 3 years, along with supporting documents like T4s and notices of assessment. They're essential for calculating child support based on income, determining spousal support amounts, ensuring fair asset division. And failing to disclose tax information can result in legal consequences and delay proceedings.
Can you see how that plays out in your own experience? Like how these seemingly simple requirements actually serve really important purposes? But Ken, let's talk about what happens after all this disclosure is complete. What's the next step?
Once both parties complete disclosure, that's when the real work begins. The process moves into negotiation phase. Lawyers review all the disclosed information, financial advisors provide guidance, and both parties work toward a legally binding settlement. The comprehensive transparency allows for fair asset division, accurate support calculations, identification of any financial concerns, and drafting settlement proposals based on real data.
So the disclosure really is the foundation for everything else. But what are the consequences when people don't do this properly? Like, what's the real price of cutting corners?
The consequences are serious, Sarah. Proceedings get delayed, sometimes unavoidably because banks only hold data for up to 8 years, but often because of incomplete submissions. Reputation gets damaged. Lack of honesty spoils the goodwill needed for smooth separation. There are disruptions and additional fees when lawyers have to chase up missing information. And in extreme cases, detention, imprisonment, warnings, fines.
You mentioned a case earlier. Can you tell us about that?
Yeah, Blaney v. Blaney. The Ontario Superior Court ordered the husband to pay costs because he continually delayed providing financial disclosure. It's a perfect example of how the courts will enforce these requirements and make the non-compliant party pay for their delays.
That's a powerful example. Now, you work in mediation as well as being a CDFA. How does financial disclosure work differently in that setting compared to court proceedings?
In mediation, and this is something we really emphasize at Divorce the Smart Way, we spend significant time educating clients on the importance of disclosure. During mediation sessions, I provide reference materials, videos, access to our financial disclosure wiki and interactive portal. We use the same standard court forms, Forms 13 and 13, but we build them into advanced settlement analytics that help clients reach settlement faster with more clarity and certainty.
That sounds like a much more collaborative approach. And you mentioned your soft landing settlement method earlier. How does that specifically address the financial disclosure challenges?
The soft landing method is designed to be collaborative and cost effective. We can often help families reach amicable agreements in as few as 4 sessions. By emphasizing full financial disclosure from the start, we build trust and credibility, reduce costs, shorten resolution timeframes, and strengthen everyone's legal position. It's about creating transparency that leads to lasting agreements.
4 sessions. That's remarkable compared to what some court battles can take. But let's talk about your disclosure workshop. What exactly is that, and who would benefit from it?
Our disclosure workshop is really focused on one critical area: family law financial disclosure. It pinpoints the specific legal issues you're addressing and strategically positions you ahead of those issues through meticulous financial disclosure. The workshop builds trust, reduces costs, shortens resolution timeframes, and strengthens your legal position. It's affordable, efficient, and effective.
So it's like getting ahead of the game before things get complicated. That makes a lot of sense. Ken, as we start to wrap this up, what would you say to someone who's listening right now and thinking, this all sounds overwhelming, I don't know where to start?
First, don't try to navigate this alone. The process can be daunting, but with the right guidance from professionals like family lawyers, divorce mediators, or CDFAs like myself, it becomes manageable. Remember, the goal isn't just legal compliance, it's ensuring both spouses can make informed decisions and reach agreements that are fair and equitable. Full disclosure paves the way for a smooth transition to the next phase of your life.
That's such an important perspective. It's not just about following rules, it's about building a foundation for your future. And I think that really connects to understanding your financial reality being crucial for a smooth divorce process.
Exactly. And here's what I always tell my clients. Transparency during separation isn't just about the law, though it absolutely is legally required. It's about creating the conditions for resolution. When both parties know exactly what they're working with financially, negotiations become more productive, agreements are more durable, and people can move forward with confidence.
So as we wrap things up, let's do a quick recap of the key takeaways. Financial disclosure is legally mandatory. You can't divorce without it in Ontario. It requires comprehensive documentation of assets, debts, and income for 3 key dates. The process has 6 different levels depending on complexity. Cutting corners can invalidate your entire agreement, and being thorough up front saves money and time in the long run.
That's a perfect summary, Sarah. And I'd add that professional help makes this process much more manageable, whether that's working with a CDFA, a family lawyer, or going through mediation with someone who understands both the financial and legal aspects. Like our soft landing method, having expert guidance ensures you're protecting your financial future properly.
What might you do differently now that you understand the importance of full financial disclosure in divorce proceedings? Maybe you'll start organizing your financial documents now, even if divorce isn't on the horizon. Maybe you'll approach the process with more openness if you're currently going through separation. Or maybe you'll seek professional help to make sure you're doing everything properly from the start.
Those are all excellent approaches. And remember, this isn't just about avoiding problems. It's about creating opportunities for fair, lasting settlements that set you up for financial security in your next chapter. The temporary discomfort of gathering all these documents pays dividends in terms of peace of mind and legal protection.
Ken, for our listeners who want to learn more about your services or maybe schedule that Get Acquainted call you mentioned, where should they go?
They can reach out to learn about our soft landing settlement method, our disclosure workshop, or just to discuss their specific circumstances. As both a mediator and CDFA, I'm uniquely equipped to address both the financial and emotional aspects of separation. The goal is always to help couples find common ground and reach resolutions that benefit both parties.
Perfect. And on that note, remember that understanding your financial picture completely isn't just a legal requirement. It's your pathway to a more secure future. Stay curious, keep those questions coming, and don't be afraid to seek the professional help you need during this challenging time.
Couldn't agree more. Until next time, keep building that foundation for your financial future, and remember, transparency today creates security tomorrow.
Until next time, keep taking care of your financial well-being. Thanks for joining us on the Soft Landing Divorce Podcast.
And that's a wrap on today's episode. Here's the truth. Divorce doesn't have to be the financial and emotional nightmare the industry often makes it seem. You have more choices than you've been told, and more strength than you may realize. But here's what we've learned from helping countless families. Understanding your financial reality is crucial for a smooth divorce process. It's the foundation that makes all those other choices possible. If today's conversation sparked something for you, we'd love you to take action. First, hit subscribe on the Soft Landing Divorce Podcast, because the strategies we share in upcoming episodes could be game changers for your family. Second, leave us a review to help other people who desperately need this information find us. And if someone you know is navigating separation or divorce, share this episode. Sometimes the most powerful gift is showing someone they're not alone and there's a better path forward. You'll find all our resources and connection links right in the podcast description. Remember, we're not just here once a week, we're building a community that believes divorce doesn't have to destroy families. Keep moving toward your soft landing. You've got this, and we've got you. That's Ken and Sarah. See you next time. Disclaimer: the information provided in this podcast is intended for general informational purposes only and does not constitute legal advice. For legal guidance specific to your situation, please consult a qualified legal professional in your jurisdiction.